phenomenal, and thank you to the organizers for doing an amazing job, and to Audrey and my fellow panelists. I've been given the task of introducing immigration detention in Canada. If we could just do an extremely quick show of hands, how many people have a basic understanding of how immigration is controlled in Canada? So, most people, great. And how many people are interested in learning about C-31 and the mandatory detention provision that's been legislated? Okay, great. So that makes it a little bit easier. So as mentioned, I'm not a legal scholar. I'm a political scientist and theorist, and something I always look for is a definition of the phenomenon that I'm studying. And it took me 6 years and no results to find a definition of immigration detention, because it's very elusive and yet very powerful, and it seems to undergird and support a lot of immigration control measures without being explicitly mandated for in many cases. So the definition that I've come up with for immigration detention is the holding of a non-citizen or a migrant, for the most part, for the purposes of realizing an immigration-related goal. The facets of this definition include that there's a deprivation of liberty. It's supposed to be for immigration reasons, not for security, not for criminal reasons. It's an administrative tool. It's a step in the regularization of immigration control. It's, according to both norms and conventions and lots of socio-legal work, it's always meant to be a measure of last resort. And after all other tools have been exhausted, then states can have recourse to detention. And unless there's a mandatory detention provision, it's a discretionary decision taken by border guards or government officials. There are three key target groups of detention, for the most part. These are irregular migrants, asylum seekers who are awaiting a final decision on their Geneva Convention or other refugee status determination, and asylum seekers whose refugee status determinations have been finalized and they've been given removal orders. There are maybe 5 reasons governments give to justify their use of detention. These are to determine identities of new arrivals. So when people are brought to the attention of the government or the border officials and they're not sure if it's the same person as it's in the immigration documents, the government wants to hold them and find out if that's the case. To facilitate deportation, to prevent admission of someone who poses a risk, and from my understanding, that's defined in Canada as criminality, security or dangerousness grounds, or violations of human or international rights. And the 2 much more shaky reasons that are given commonly are to prevent someone who would otherwise abscond. Absconding is to purposely evade border control, so we may know it as flight risk or going underground. Detention is meant to deter this, and to deter certain people from immigrating in the first place. Detention is a worldwide phenomenon. The largest detention system in the world is the United States. There's over 400,000 different people in detention every year in over 250 official facilities. And I should say individuals because people may be detained at any time in their immigration or refugee status regularization process. So they can be detained on arrival at any time during their residence and before deportation. So these statistics don't necessarily include people who have been redetained. It's 400,000 different people who are in detention.
Is that Canada only?
That's in the USA. That's the largest system. The UK is next. Australia is a system that's often compared to the Canadian one. And it's basically in every other state with a developed immigration control process. Since 2004, there have been approximately 95,000 people detained in Canada. And we don't know, again, if that's the redetention or individuals. The majority of them, about 70%, are held in what the government refers to as immigration holding centers. This is basically a euphemism for an immigration detention center. In the US, they're called immigration service processing centers. In the UK, they're immigration removal centers. In Canada, they're immigration holding centers. There are 3 in what we call the MTV cities, so Montreal, Toronto, Vancouver. Other sites of detention are usually at any sort of port of entry or major metropolis area. And as of the 8th of November, there were 60 people who had been detained for over 1 year being held in detention on that day as a snapshot. I assume we all understand how the legislative foundations of IRPA, the Immigration and Refugee Protection Act, the Citizenship and Immigration Canada Policy Manual on Detention gives guidance on how the day-to-day operations should run. And then most recently we have C31, the Protecting Canada's Immigration System Act. I should mention that detainees are usually divided into two groups. One is high-risk detainees and one is low-risk detainees. 70% of detainees are considered low risk, and they're sent to the immigration holding centers. The high-risk detainees could be people who are generally either of quote-unquote criminal backgrounds, who may pose flight risks, and interestingly, who have mental health or behavioral problems. These three groups of people are all considered high risk, and they're sent to provincial remand or correctional facilities, so jails like the Lindsay jail, which I'm sure you will also discuss in more detail. There are children in Canadian detention facilities. As we know in law and policy, children should not be detained except as a very last resort. However, we know that between 2005 and 2010, there were approximately 409 children detained annually. We think that the number is actually higher because children may be detained as guests of their parents. This means they're accompanying their parents and they're not officially being detained, and they do not turn up on the statistics of official children in detention. So we think the number is higher. There have been 2 deaths in detention that I know of. One, Jan Samko on December 8, 2011 in the Rexdale Immigration Holding Center here in Toronto, and a more recent one of Lucia Vega Jimenez, who died after a suicide attempt in the Vancouver Immigration Holding Center on her suicide attempt was on December 20th, and she died 8 days later. As a little bit of background for C31, in section 20.1, subsection 1, the Minister of Public Safety, not the Minister of Citizenship and Immigration Canada, but the Minister of Public Safety, may designate 2 or more foreign nationals as a group of irregular arrivals because of administrative convenience or suspicion of smuggling or trafficking. There's a 2-week review of refugee admissibility. If this review does not pass, and the people become so designated as a group of irregular arrivals, they may be subjected to 1 year of mandatory detention without a court warrant that is automatic and reviewable for 6 months, and then every 6 months, and for all persons aged 16 or older. And there's a discretionary power to detain children under 16 or to forcibly separate them from their parents for that year. There's also no access to appeal before the Refugee Appeal Division. Some common issues in detention in Canada and elsewhere include overpopulation and exposure to violence. There's no statutory right to counsel or translation. There is, time again, we find deterioration in mental health. This may take the form of post-traumatic stress disorder, depression, anxiety, aggression, and mental health-related disability. There are also suicidal tendencies, as we learned about Lucia Vega Jimenez. There's also inadequate medical, psychological, and hygienic care often in detention. There is a question of the opaque roles that are played by private firms. So the immigration holding centers are staffed by firms that are subcontracted to the government. We know very little about these firms and who is responsible for them on a day-to-day basis. There's the question of children in detention and other vulnerable people, including pregnant women, torture survivors, disabled people, older people, etc. And there's also a long-term trauma that's associated with even small stays in detention. And this has an especially marked effect on children's cognitive and emotional development. And I would just like to end by saying that there is no effect on deterrence. Detention, theoretically, it's very difficult to prove that you can deter somebody from doing something because they haven't done it. But if we put that aside, we notice that there's no evidence that detention deters amongst all of the qualitative interviews that we've done with people who are in detention. There are structural factors that outweigh detainability. These include visa policies, the difficulty of the migrant journey, the fact that the government goes to Hungary and puts up billboards and says, don't come to Canada, and that we know that detained or deported migrants do not often spread word of this danger to potential migrants. And we also know that agents, who are sometimes referred to as smugglers, will assure migrants against their own susceptibility to detention. So all these factors and more show that there is no effect of detention on deterrence. In fact, I'm sure we'll talk about this, but there is no legal basis for implementing detention on the basis of deterring. But this is a justification that's often brought up in the media and colloquially. But again, there is no effect on either irregular migration or working without authorization.
Thank you very much.
What Stephanie's comments and what Deepan's will be, I think, in context. If someone commits a criminal act or is engaged in criminal activity, Canada's responsibility is to prosecute them, or if the offense occurred outside of Canada, to extradite the person to face prosecution somewhere else. That's the responsibility. It's not to deport the person. Deporting the person without ensuring that they're extradited to face prosecution or without prosecuting them in Canada merely sets a criminal off in another country, and in some instances can constitute a human rights violation where, like Deepan, who's been here his entire life, was born here, it constitutes exile or banishment, and that's what's happening in Canada. So there are cases, if you go back to the Supreme Court of Canada judgment in 1933, the Royal Prerogative of Mercy case, the court said deportation was not meant to punish the person. That was reaffirmed by the Federal Court of Appeal in the early 70s in a case called Heard, that deportation is not meant to punish people, but in fact that's what's happened. Deportation is being used to punish people. It permeates the immigration system and the federal court decision making. It started, I think, the most directly in 1992 when the government made people inadmissible for membership, for pure association with an organized criminal group or with a so-called terrorist organization. So every popular resistance movement in the country, in the world, is a terrorist organization if they've engaged in violence, unless they're friends of Canada like East Timor, in which case we don't identify them as terrorists, but everybody else we identify as terrorists. It doesn't require that the person did anything wrong, but it results in deportation, even though the person, for example, if you take the Palestinian issue, the person might have been a dentist in a Palestinian clinic that was funded by the PFLP. Or the person might have been a Tamil living in the north under LTT control and worked as a family court judge under the LTT administration. They did nothing wrong, but they are being penalized and punished because of it on standards which would never be accepted by any civilized country as standards that are reasonable for determining fault. There is no requirement of fault. That analysis or that punishing people for what's perceived to be wrongdoing is there in the federal court jurisprudence, not just in upholding membership. One of the judges who's now Supreme Court of Canada Justice Rothstein, said that, and I think he's the judge that first coined this, that membership has a broad and unrestricted definition. Well, how can you have an unrestricted definition and still have a definition? Sorry, it doesn't cut it. It took like 10 years for another judge to finally say you can't have an unrestricted definition, but that judge is still down here. Justice Rothstein's up in the Supreme Court of Canada. So the court has used a broad definition of membership. It reaches to people guilty of wrongdoing. I'll give you the best example that I always give is the Joseph case. Mrs. Joseph, her husband was a member of parliament in Sri Lanka. He was a member of parliament elected democratically for the Tamil National Alliance. Tamil National Alliance was a group, a democratic party in Sri Lanka, but it spoke on behalf of the LTTE in the peace negotiations to try and end the war. You think there's a problem with that? Our government thinks there's a problem with that because it spoke on behalf of the LTTE to try and end the war. The LTTE, our government thinks, is a terrorist organization. Mrs. Joseph's a terrorist because her husband was a member of parliament in that party. The party was linked to the LTTE. She raised his kids, she cooked him dinner, and she wrote his notes up. She's a terrorist. That's how broad the fault is in terms of the Immigration Act. When it comes to detention, those people are the ones that are generally detained, and those are the people that we have the hardest time getting at. So in security certificate cases, which the government rarely uses now, but they're considered the top line of terrorists. The government only uses them in really serious cases, they say. They didn't even get a bail review. They were so dangerous that we just put them in jail and threw away the key until the case was decided. 2, 3, 4, 5, 6 years later, we're still trying to finish the cases. They're still detained. It took the Supreme Court 10 years because they dismissed Lee when that was first raised in 1992. Actually in 1997 by the time it got up there. And in 2007, the Supreme Court said you can't have detention without bail. It's arbitrary. There has to be someone looking at the need to continue detention. So what does our government do? Our government then passes a law, which Stephanie was talking about, which puts designated foreign nationals in jail for a year with no review. We just won the issue in the Supreme Court of Canada, and we're now facing the same challenge again. Can you put a person in jail, even if it's just for 1 year and not 7 years, like the security certificate cases, without a review? According to the Supreme Court of Canada, you can't. But those cases, designated foreign nationals, are somehow more at fault than other people because they came irregularly. Well, what refugee didn't come irregularly? Most of them do. So what it does is it penalizes refugees for seeking safe haven in Canada and faults them both by detention and by putting their cases through the system quicker. Again, it's another aspect of criminalizing, what people do in order to save their lives. The other aspect of detention outside the security kinds of cases and the designated foreign nationals is the association costs. I just lost a case in the federal court. It's Brucesi, where I had argued that you couldn't find someone to be a danger purely on association. You had to analyze the evidence. Did this person have a record of danger? Or, you're going to have to put it up again because I don't have a clock.
I will.
Did this person have a record of violence? The organization he was alleged to be involved in, does it have a record of violence in Canada? That you have to look at those kinds of factors before you decide a person's in actual danger? Court said, no, you don't. For the first time, they've said it's pure association. It doesn't matter that there's any danger. There is a presumption, not a presumption, there is, it gives rise to a conclusion that the person is a danger. And although it's the first time the case has ever been, that issue's ever been determined, the judge didn't certify a question. We can't appeal. There's no appeal. So that whole issue around association itself is, we're cut off from having any other court look at it. That's another problem with the immigration system. You never get up to the higher courts in most cases because the judge who refused your case is telling you you can't appeal, and that's the only one that can tell you you can appeal. The way around it in these kinds of cases is to use the age-old remedy of habeas corpus, which is something that we will end up doing at some point, and go back and try and do that. The last thing I want to kind of talk about is the Citizenship Act amendments, because I think it is more of the same. It is an effort on the part of the government, this time not to deport because of criminality, or exile or banish people. It is to move that into the citizenship realm and take away citizenship from kids born in Canada. I know Deepan was born in Canada. They say he never had citizenship. In the Citizenship Act amendments, the government's going further in saying, yes, we know you had citizenship, but if you can get citizenship from another country through one of your parents, and you're guilty of certain defined offenses that we can characterize as terrorists, and you got a 5-year sentence for it, doesn't matter if it happened before we changed the law or now, we can take your citizenship away from you and remove you from Canada. That's pure exile. If you go back historically, the last time Canada did that was in the Second World War. They took citizenship away from Japanese Canadians, and removed them to Japan. There's a case I'm pretty sure it's I can't remember if it was the Supreme Court or the Privy Council, but it was 1945, in which the court said that's okay. You can take citizenship away from people like that. So when you think of it, we have a Charter of Rights and Freedoms, which gives citizens a right to live in Canada. It is nothing if they can take it away from you by a piece of legislation. What does it mean? Citizenship's not solid at all. This government's pointing that out to us through these kinds of changes. And I can tell you, they're doing it. 5 years is not a serious sentence for someone convicted of terrorist offenses, a life sentence is more likely for people who truly were engaged in terrorist activities. They're doing it to get Omar Khadr. Omar Khadr is a second-generation Canadian, but his dad was from Egypt. Egyptians recognize citizenship through descendants, and a 5-year sentence, no one would pick a sentence that low unless they're trying to get him on an 8-year sentence. So you can be sure they're going to go after Omar Khadr as soon as they pass the citizenship amendments, after all that kid has gone through. So, in any event. So I think that what we've done is we've turned the immigration and now the citizenship, not we, this government, not just this government. In the past, the successive governments have criminalized the immigration and detention process. This current government is criminalizing the citizenship process, citizenship in Canada. They're using it to punish people.
And our next speaker is Deepan Budlakodi.
Hello everyone. My name is Deepan Budlakodi, and I'll be talking to you today about my case and what is happening with me and how I became stateless in Canada. I got charged when I was 19 years old, for a transfer of a hunting rifle to an undercover cop. I was put in OCDC, Ottawa Carleton Detention Center. While I was at OCDC, I got into an altercation with a guard. I was thrown in the hole for 30 days. While I was in the hole, a guard asked me if I was a citizen or not. I told the guard, of course I'm a citizen. Once I was taken out of the hole, a CBSA officer came to see me stating that I am not a citizen. I'm considered a long-term permanent resident. I provided him a copy of my birth certificate and a copy of my Canadian passport. To me, if you provide these two documents, you would think that it would end right there, but it went above and beyond. He came back saying that my Canadian passport was given to me in error, administration error, and I'm classified as a long-term permanent resident. At this time, I contacted the public safety minister, contacted media. The public safety minister intervened in my case, stopped my case for about a year, and then when I got sentenced, my deportation order recommenced. At Ottawa Carleton Detention Center, or at Toronto West Detention Center, or in the pen, I want to specify that people believe that while you're inside, it's like a Holiday Inn. Like some of these jails in Vancouver are called Holiday Inn, or at one point we're called Holiday Inn. The jail's not a Holiday Inn. There's blind spots. When I differ from my blind spots, there's spots where the cameras don't see where you are. Guards will physically attack you. They will take you to the hole. They won't give you the ability to see your lawyer. They won't give you the ability to see your family, so forth and so forth. So I just want to make that very clear that there's a lot of corruption that's happening inside. Now, once I went to Joyceville Penitentiary, I had an admissibility hearing. During my admissibility hearing, the member or the adjudicator had the ability to stop my deportation completely. But he chose to continue on my deportation based on the fact that he stated that he didn't have the jurisdiction to continue on with the evidence I'm presenting to him. So he's basically saying that it's above his pay grade. So deportation order came. A lot of evidence that I presented was dismissed. Now, once I left Joyceville, I was supposed to go back to Ottawa. But immigration decided to send me to Toronto West. It's the same type that they're using when they're taking people from Toronto West and sending them to Lindsay. It's isolation. They know my lawyer and my family support is in Ottawa, but yet they sent me to Toronto. I was at Toronto West Detention Center. I was going to give you some context about Toronto West Detention. You're in a cell with 3 other individuals. Your mattress, if you want to even call it a mattress, is about 2 inches thick. 1 guy's on the floor, 2 guys on a bunk. Toilet, you're probably about a 10 by 10 cell. Bars on the door, bars. So here's an L shape. You see this range on this side, and then you can see this side on this range. If you want to use the washroom, you have to use your own bed sheet to cover the grill and then cover the back side. You get sheets every 2 weeks. The lights are on 24/7, and a guard comes in every 15 minutes at nighttime to do a little beat 4 times in a range. So it's very difficult to sleep. No privacy, and you get treated differently than people that are dealing with criminal charges. You get locked up sooner. The guards treat you like shit. They don't believe that. They consider you like, I would say that you're not a citizen. To me, I would say they treat you like you're a dog, essentially. I got released from Toronto West Detention Center to my parents where I haven't lived in since I was 12 years old. But the adjudicator decided that it was acceptable for me to go back to my parents based on the fact that the former high commissioners, or the former high commission had stated that they're not issuing me no documents at the time. I was sent back to Ottawa on conditions where, I'll give you an example of some of my conditions. One of my conditions were if they asked my parents for documents within 24 hours, they had to provide these documents or I'll get breached. I'm not allowed to work. I'm not allowed to do any training. I'm not allowed to do any schooling. I had to apply for a work permit even though I was born in Canada, had a social insurance card. It took me 7 months before I was able to get a work permit. And in terms of getting a work permit, you're supposed to get a work permit at the time when I applied, between 3 to 6 weeks. I had to file a mandamus application. A mandamus application is an application in federal court where you get the government to seek within 20 days to give you what you're seeking or explain why you're not getting it. 10 days later, I got a work permit. Now, once I had a work permit, I had to apply for a social insurance card. I went to Service Ontario with a work permit. They denied me the ability to get a social insurance card. I had to contact Thomas McClare's office, and Thomas McClare's office contacted Service Ontario. 10 days later, I got a social insurance card. Now, going to the fact that I have a work permit and a social insurance card, I still can't work, so I had to do a detention review. During my detention review, my charter application and my UN application came into effect, and the fact that I had a public campaign. I had changed my conditions down to keep the peace, signing once a month, and reside with my new surety, and obtain a work permit. From that point on, I was able to get a job, but I want to focus on the fact that Canada is violating my charter rights, subsection 6 and subsection 7. I'm born in Canada. I had a Canadian passport. Under the Passport Act itself, it says that if you can only get a Canadian passport if you're a citizen. I got a passport on 2 different occasions. Under the Passport Act, there's no provision where they say that they took away my passport in this circumstance. They're just using a broader excuse, essentially, is an administration error. Now, I'm effectively stateless, which is one fact that Canada has violated the UN principle in terms of there's a convention in 1961, reduction of statelessness, which Canada has violated directly in my case. I'm the first case like this in Canada, someone born in Canada, in the capital city, and they're trying to deport me. And right now I'm in federal court. What I'm seeking in federal court is declaration of citizenship, breach of the Charter of Rights, and my court case is coming up possibly in June. I also have a UN application through CCLA, Saskatchewan Hele, and that's the process, possibly another 6-7 months till I find a decision. I want to also point out that I spent 3 years, 8 months in jail, 8 months pre-sentence custody, 6 months solely on immigration at Toronto West, and then 3 years at Joyceville and Millhaven. And I want to focus on one other thing as well. Immigration, CBSA, or CIC are very sneaky. 6 months prior to me even being released from Toronto West, even going to Toronto West Detention Center, they knew that India had already given their position on my case. I found out this by filing an access to information. They already furnished the decision to CBSA that I'm not Indian national and would not issue me any documents. But yet, they never provided this document to me, and they held me an additional 6 months before I got bail. So it just goes to show how CBSA will use their own ways and just try to destroy someone's life, essentially. I'm effectively stateless right now. I have no status in Canada. I have to apply for a work permit once a year. I have to apply for a driver license once a year, and I got to apply for, I have no healthcare services. I'm basically going around town and going to different universities and so forth to talk about my case, to get awareness, because this case does not only affect me, it can affect multiple other individuals. It's basically saying that someone that's born in Canada, or both parents are citizen, or not citizen, one parent is a permanent resident and one parent is a citizen, and their child is born in Canada, and that child commits a crime, that child cannot be deported. That's the type of precedence my case can possibly set. And I'll just close up by saying that I'm always looking for solidarity support. I have a website, I have a Facebook page. My website is www.justicefordeepan, same name as the Facebook page, and Feel free to ask me any questions. Thank you for taking the time to hear me.
Thank you so much for having me here, especially to the organizers, and it's quite an honor to be following Deepan and to have Audrey and Barb, and good to meet you for the first time, Stephanie. I already have a bunch of questions. I'm going to begin by acknowledging that we're on the territories of the Mississaugas of Grand Credit, that we're here on lands that have been defended for over 5 centuries by indigenous communities, that these are lands that have been lived on by the Anishinaabe people and the Algonquins in the 6 Nations. We're here in the process of 5 centuries of actually one ongoing single moment, that of settler colonialism. And that when we arrive here as migrants or as settlers, we are made into, we are metabolized, we're crunched, we're crushed, and we're chipped out into this new thing, the citizen, a citizen that is complicit in this project of erasure of indigenous communities, this project of denial of rights and services, this project that includes the mass genocide of hundreds of indigenous women, this project that is about the mass incarceration of children and the residential schools, the children's aid services, as well as the 60 Scoop. That is the project, and that project is done in the name of one thing and one thing only, the nation. And the nation is only comprised of the citizen. And so when we sit here talking about migration, detention, criminalization, and incarceration, that is the context in which we arise. I also want to begin by saying to you a few names. Shairoz Walji, shot to death the day after she met with a deportation officer. Haptom Kibraim, who hung himself outside of a CBSA office because he was facing deportation. Lucia Vega, who hung herself awaiting deportation in a dungeon in a Vancouver airport less than 3 months ago. Michael Mavogo, who's been in jail for about a decade, await where Canada cannot deport him or will not release him. Ayad al-Shamri, who is in detention for 5.5 years with lung cancer, who knows that he's going to die in there. Mabuko, an anti-apartheid hero, who has been locked away for 10 years in Canada's immigration detention facilities and will not be released. These are the names of the silenced and the murdered. These are the names that have been forgotten, have been pushed out of our memory. These are the names that I want to repeat to ourselves because their names have been replaced by others, terrorists, criminals, immigrants, not us. So I sit here from within No One is Illegal Toronto to insist that these names must be remembered. That those of us that are locked up in cages, those of us that live in outside places, those of us that have been pushed into places of fear, of indignity, and of injustice, be it inside detention centers or living on the streets of this city, that our names cannot be forgotten. I'm here because the border does not just exist at the peripheries of this nation state, that it exists actually at the doors of sites of services that you go into every day. That for a migrant mother, when she tries to walk into a school to enlist her undocumented child, there is a border. For an undocumented person trying barely to get healthcare, they have to cross a border to get healthcare services. For someone to get into shelter, they have to pass through a border. And so that life outside of those borders, that life of being pushed out is a life of consistent trauma, of consistent uncertainty, of consistent detention. And so we insist that these walls must fall. We insist that the borders that exist outside of those sites must fall. And this is why we have fought in the city to have Toronto schools become accessible to undocumented students, to change Toronto police services, to bar immigration enforcement from shelters, and only a year ago to declare Toronto as Canada's first sanctuary city. That is the work that we see ourselves doing against this process of detention and deportation. I've given you some names, but I also want to give you some numbers. Many numbers we heard from Stephanie, but I want to give you a few more numbers. 45.1 million. That's the number of people that the United Nations says are displaced and must be housed. 11,000. That's the number of people from within those 45.1 million that Canada took in. That's 0.00024%. And that is the generous refugee system we are told about. 85,000, that's the number of detainees who've been detained in this country since 2004. 40, that's the number of deportations that happen in Toronto every day. 114 million, That's the amount that immigration enforcement spends each year, a large part of which goes into putting people in detention, particularly in hiring provincial jails to lock people up. And so our work against the borders inside the city actually transfers into the work outside. And in the face of injustice, in the face of these indignities, 200 migrants on September 16 of last year decided to fight back. On September 16, 200 migrants in Lindy's Central East Correctional Center, the same facility with services as Deepan described, refused to enter their cells. A riot squad was called and they were beaten back in. The following day, they went on a 24-hour hunger strike. They were faced with violence and coercion. 3 days later, on Monday, an unlimited migrant hunger strike was declared, a historic moment in Canadian history, following on a long-term history of prison resistance. Many of those migrants were forced off their hunger strike within 8 days, but at least 2 continued for 65 days. 65 days without food and water, eventually. Why? Because they were being detained indefinitely. They were put into isolation. They were denied access to friends, family, lawyers, everything. For 20 days, we tried everything we could to get them out. We couldn't get through to them, the lawyers, their lawyers, our friends couldn't call them, and eventually they were released. But in spite of that, the migrant strike has continued. Just over a month ago, there was a symbolic 3-day hunger strike. Migrants have refused to go to their detention reviews, have refused services. It spread. The Toronto Immigration Holding Centre tried to organize a strike. Key strike organizers have since been deported, and some have been released. And so now we're working with migrant detainee organizers who are on the outside, who are now dealing with all kinds of trauma to be released back after 32 months. So work is focused on 4 key demands. And the demands are: 1, a 90-day limit on how long someone can be detained pending deportation. As you may well imagine, we oppose detention in all its forms, but Canada is the only country in the Western world, the so-called Western world, that doesn't have a limit on how long someone can be detained pending deportation. So we're asking for 60 days. We're saying that migrants should not be held in maximum security prisons, because as we know, that these maximum security prisons are places of immense injustice, and that nobody should be in them, but migrants shouldn't be in them for sure. We have to remember that these are administrative holes that fall sort of in the same general legal place that not paying your parking permit does. And how can you be put in jail to be separated from your families, from your children, for a decade almost because of something like that? We're saying that the detention review process needs to be overhauled. And we're in the process of putting out reports to show that there's massive discrepancy where, depending on where you are actually getting your review done. So in some cases, the release rate is 6%, in others it's 40%. And when there is discrepancy that big, it is arbitrary. It's about racism. The majority of these men happen to be black men. And that is not because of any other thing but an ongoing project of racism and exclusion. I want us to remember that now, on multiple occasions, these people who were detained and could not be deported, Canada has tried to deport them to multiple countries that weren't theirs. In one case, in the case of Michael Movogo, the Canadian government actually hired an international smuggler to create fake documents to send him to a different country. Amin Majasiri from Kenya was tried to be deported to Tanzania. He was returned. Christopher was from Jamaica. They tried to deport him to the Bahamas. He was returned. Right? We know of 3 men who this has happened to, and that's just in the last 6 months. Okay? We're talking about a shadowy, corrupt agency that exists outside of political purview, outside of civilian oversight, that exists to further that ongoing settler colonial project, that of creating fear, that of locking us away, that of ensuring that even those who are citizens will continue to be part of the project, because not being a citizen means being a migrant, means being a terrorist, means being a criminal, and that is what we must fight against. And finally, we have to ask ourselves how it is that these systems of immigration, colonialism, incarceration, and racism are actually working together, right? Who is it that is first locked away in prisons on criminal charges? We know in this city that the Toronto police has a file on every black and brown man, right? So those are the people who end up in jails. Those are the people who get sentenced. Those are then the people who get their immigration status taken away. So we cannot separate these things, and we must find places of openings. So for us, we're trying to go to the Federal Court of Canada, and this, hopefully, the United Nations to talk about this maximum, a maximum limit on endless detention. We're going to the Human Rights Tribunal to talk about how to end incarceration in max security prisons. Those are legal things, and those are legal things that are in solidarity, accompanying the indigenous land defenders who've been here struggling against these things for 5 centuries. Thank you.
Sophia?
I have I guess it's for anybody, but maybe for Jackman. In the detention review process, when, like, what are lawyers actually representing anybody in the detention reviews? How does it get out of the detention review cycle of, like, doing, like, 30 detention reviews or 40, and then how does it get out of that into the federal court, and are there lawyers that are, doing that? Do they have representation at these hearings? So, it's for anybody, but.
You might know some of it too. Most people go to the detention reviews without counsel. You can seek to review a detention in the federal court, but you have to do a written application and ask for leave to have the court hear it. If the court grants leave, it's a year. So detentions reviews are every 30 days. So as soon as you bring an application, you've already got another detention review. They won't put it over. They do them whether you're ready or not to have your hearing. And so most cases end up not going to court. We just went through that Brusesi case. We just went through hell trying to get it before the federal court. We ended up with 5 detention reviews records before a judge, but I went to the Ontario court twice on a habeas corpus application to force the federal court to hear it in a timely fashion because it wouldn't expedite. So we went to the Ontario court, and then of course the federal government says, well, we're prepared to expedite after they've already told federal court they don't want to expedite. But it was, I mean, you use your like just incredible efforts to get a case heard in federal court, and that's when we didn't get a question certified. So where does it leave us? If we'd gone to the Ontario court on habeas corpus, we would have had the case heard in 2 days, some of them, certainly within a week, and we would have had a right to appeal. It's not satisfactory, the review system in federal court. The indefinite detention thing, I just wanted to say we did argue indefinite detention in the security certificate cases. There's a line of cases in the U.S. Supreme Court that talk about how if you're not going to be removed, the reason for detaining you is unhinged from the purpose. The purpose is to remove the person. And so we argued in Jabala's case that it had become unhinged. The case had been going on since 2001. We were in 2009. There was no end in sight. His case is still going on. It's still not resolved. And the court said it wasn't unhinged because at some point, some mythical point in the future, he will be removed. Meanwhile, he's now a grandfather. He's now got 5 grandchildren. I mean, it's like at some point he becomes like Deepan. He's so Canadian that it's impossible to remove.
So we have about seven clients, so 7 detainees who are in long-term detention that we've been trying to get through the detention review process. And as Barb said, many of them choose to go to detention reviews because there's repetition, right? Like we're talking about people going to 50 to 70 of them. So there is a boycott that's starting. So a lot of people are just boycotting the detention reviews because they do not believe that there is any access to justice there. For each of those cases, when we've tried to go to the federal court on constitutional grounds, so those were rejected. Basically, we're saying it's arbitrary and indefinite detention. When we've tried to go to the federal court, those have been rejected. We just haven't gotten leave. We're in the process of pulling together 3 people's cases and try and push them together at the federal court. Hopefully that'll help.
Don't go to federal court. I think the ground's laid to go back on habeas corpus.
I don't even know
I
what that
really
means,
think-
but I will pass that on to the legal team. And the other thing that we're doing is we're trying to go to the United Nations. So we filed at the United Nations Working Group on Arbitrary Detention. But as soon as we filed, they are now prepared to release the person, which would take away the ground. So that's happened once before. So that's the other thing. So it's a political game that's being played in a lot of ways, and it's in the press, particularly around When it came out that CBSA was hiring smugglers, they fired Reg Williams, who's the second in command in CBSA in Toronto, and he did a piece at the end of December in the Toronto Star. So there's a lot of internal fighting happening about this. As I said, we're going to be putting out a series of reports over the next, just to show how broken the system is, which hopefully will help. But in the actual legal process, I don't see it opening. But I don't know what Barb just meant, so I will put her in touch.
Yeah, I see a couple of questions, and forgive you in the red shirt, yes. And then I see in the back, okay, I see three of you so far.
Okay, so my name is Beatrice. I am a law student here and a caseworker at Downtown Legal Services in the Refugee and Immigration Division. I was just wondering, and this is a question to the panel, if you can answer two broad questions for me. One was about access to justice, and that relates to the location of some of the detention centers, because I can imagine that just in terms of having legal counsel, it's an impediment for some lawyers to actually come out to detention centers depending on where they are. So I'm wondering if that's something to address. And the other thing was about health. You were saying that access to health services is very difficult for people that are in detention. And I'm wondering about how that could be addressed, physical as well as mental health, because both of these are important.
Well, I can talk a bit about the locations. Even though I understand that access to justice is a term of art, so I'll probably just bracket that. But so some of the detention centers, the way I describe them is they kind of look like highly securitized libraries. And so it's part of the criminalization of migration, because when these detention centers are either purposely built within the community as this very overbearing, demanding architecture style, then people in the community start to wonder who's being taken there. And so if they look like criminals, they're in this building that looks like somewhere that criminals would be held. Therefore, the implication is they must have criminal affiliations or they're criminal. So I think your point about them being far-flung is extremely important, and this is a major issue in the United States and the UK as well. And even in Toronto, even though the detention centers in Toronto, we all know traffic is terrible here, and it can take over an hour just to get there. So sometimes locations can be far-flung even within the metropolis area. But this criminalization effect of what it looks like then filters out into these sort of NIMBY responses as well, so they're not in my backyard. We don't want to be involved with this element, and then there's a counter argument too that detention centers are built in places where the local economy is suffering, and they are the promise of many jobs. So this can galvanize already marginalized population to support detention just based on the jobs that could be created there, and then the necessary dehumanization of the people who live within as well. And I don't know if somebody else wanted to take the rest of the question.
They used to have, when I started practicing, this goes back probably before a lot of you were born, they used to have the detainees that were not criminal detainees, so the ones that weren't put in jail, they were right in a downtown hotel. And for years it was in the downtown hotel. I think they moved them outside of the city because of cost. And so they could have them downtown. There wouldn't be any problem with it. It is a problem in terms of access to justice, just because of the timing. Like, first of all, Lindsay, which is where a lot of them are held, you have to have a car, because if you take the bus, you're there for 2 days. The timing is really bad. And you don't get time to prepare properly with clients. And I think that the American studies, you probably know, Audrey, show that people who were detained, when we did the Safe Third Country Challenge, people who were detained lost their cases at a much higher rate than anybody else because of the inability to have sufficient time on visiting hours to prepare your case and to work yourself at getting your documents. Health, I think they destroy people's health. It's not just a question of having access to doctors. Do you know, in Hassan Omre's case, he was my client, solitary confinement 5 years. He still has nightmares. And it wasn't because of torture in Syria or Saudi Arabia. It was because of his treatment in Canada. He suffers post-traumatic stress. It is not surprising because of what he went through. But we had to go to court. He was at Toronto West, a jail, maximum security jail, huge cement edifice, like big building, freezing in the wintertime, so cold that the guards wore jackets to work when they were on shift. He was in solitary in socks. They wouldn't let him wear shoes. They were slip-on runners, because rubber shoes, because he might throw them at a guard. It was policy not to let people in solitary wear shoes. It could be heavy if you got it wet somehow and then threw it at someone. The guards actually came and testified on his behalf because the conditions were so cold. But we went 6 days in court arguing about a pair of shoes. The judge ordered that they give him shoes to wear. You can't put someone in jail 5 years walking on a cold floor. He has health problems because of that, too. I mean, it's just like, it's not, and that's one of the problems. It's Hannah Arendt's, the banality of evil. These are ordinary Canadians, and you can't look at one individually and say, oh, you're someone who would torture if you had the chance. But their treatment of people collectively in the system through the institutionalization is harsh and cruel and has a very, very detrimental effect on the well-being of people in Canada. I mean, it's one book to read, Antonio Cassisi's review of mistreatment in European jails. It's appalling. Like, people with their teeth rotting can't get dental appointments. It's no different in Canada. Europe is another civilized set of nations. We're a civilized set of nations, but we're not civilized when we deal with people like this.